My name is Russ Feingold, and I'm the president of the American Constitution Society, the country's foremost progressive league organization with more than 200 student and lawyer chapters across the nation. ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers and judges and advocates, and ensuring that the law is a force to improve the lives of all people. We are especially focusing our work in this anniversary year on our Constitution's founding failures when it comes to race and equality in this country, and reckoning with our past to create a more just future. If you don't know already, we encourage you to follow ACS on social media, including on Twitter at ACS Law. You can also find us online at acslaw.org. There you can join ACS and find more information about upcoming events and opportunities. Thanks for joining us today for part 2 of our 2-part series on how to reform the presidency. Last week, we discussed the office of the presidency and what reforms are needed to protect the institution of the presidency from a rogue president. Today, we're going to move down Pennsylvania Avenue to focus on the Department of Justice and how to ensure that the department can pursue the impartial administration of justice. A disinterested, nonpartisan law enforcement apparatus plays a central role in ensuring that the public maintains faith in the fundamental fairness of our criminal justice system. But over the course of his 4 years in office, Donald Trump's presidency worked hard to dismantle the norms and practices that since Watergate have emerged within the executive branch to guarantee that independence. From calling for investigations into political opponents like Hillary Clinton and demanding action against corporations like Amazon and Time Warner, whose owners control media outlets that he perceived as unfavorable, to asking then FBI Director James Comey to let this go with respect to the investigation of Michael Flynn. The Trump administration interfered in numerous law enforcement matters. The question now becomes how we can prevent future administrations from undermining the department's independence. Building off the reform suggestions that Bob Bauer and Jack Goldsmith put forward in their recent book, After Trump, Reconstructing the Presidency, today's session will dig into how to reform the Department of Justice. Our discussion will focus on how to investigate a president or a president-elect who threatens our national security, law enforcement independence, and reforms to how the Department of Justice and White House interact, including the respective roles of the Office of Legal Counsel and the White House Counsel. We have an impressive panel of experts with us today. First off, we have the book's authors, Bob Bauer, who is a professor of practice at NYU and former White House counsel to President Obama, and Jack Goldsmith, who is the learned hand professor of law at Harvard and former Assistant Attorney General for the Office of Legal Counsel. They are joined by Asha Rangappa and Jeannie Rhee. Asha, I remember that you were the Director of Admissions and Senior Lecturer at Yale University's Jackson Institute for Global Affairs. I used to see you there when I was teaching, and formerly worked as a special agent at the FBI. Jeannie is currently a partner at Paul Weiss and previously served with Robert Mueller in the Special Counsel's Office, and also previously served as Deputy Associate Attorney General for the Office of Legal Counsel. Now, to get this conversation started, I'm going to turn it over for today's moderator, Alan Morrison. Alan is the Lerner Family Associate Dean for Public Interest and Public Service Law at George Washington University Law School. A prolific Supreme Court litigator, Alan has argued over 20 cases before the Supreme Court. He spent most of his career working at the Public Citizen Litigation Group, which he co-founded in 1972 and directed for over 25 years. And perhaps most importantly for our purposes, he is the faculty advisor for the ACS chapter at GW. We are so glad he is with us today to moderate this discussion. Alan?
Thank you, Russ, and thank you, ACS, for allowing me to actually have a program about a book that I read and loved and just want to bring it out for everybody to talk about and see what great ideas there are here. So let's get started. And we're going to begin today with our discussion about something that we hope is never necessary again in the future, which is that the Justice Department has to appoint a special counsel to investigate the president and his allies. But knowing that that is not likely to be the case, the question I want to pose to Bob Bauer is, Bob, what do you think about the special counsel's office? It exists only by regulation now. Should Congress put this into a statute? And if so, should it be amended in what respects?
So speaking for both Jack and me, speaking about the proposal set forth in the book, I can say, and this is certainly true of me personally over the years, I'm not keen on a return to the independent counsel experience of the 1980s and 1990s. There were all sorts of features we can discuss of that particular structure that I thought were problematic and that in practice, I think demonstrated their weaknesses. And so for that reason, I do think that for the time being, and of course, we can always reevaluate as we go along and decide that something we hope would work well didn't work as well as we hoped and continue to refine. This is not a problem to which there is a clear and definitive answer. But in the meantime, I think our best bet is to draw on experience and to revise the special counsel regulations. They were a response. They were developed in response to the failures of the independent counsel statute as widely perceived at the time. There are some who would like to see that brought back, but at the time widely perceived on a bipartisan basis to have created difficulties and not to be subject to renewal. And so there are aspects of the council regulations that in light of experience since they were first promulgated that I think bear re-examination. And by the way, not all of the thoughts that we have on this subject are based on the experience with the special counsel regulations the last time they were invoked, and that is in the case of Robert Mueller. And as Jeannie knows better than I do, I mean, there are multiple appointments here. The special counsel regulations were made applicable to the work of Robert Mueller, but he was essentially appointed under different authority. And nonetheless, I think it did give us a look at some issues that I think do require attention, and hopefully some administration, maybe this one, will take a look and revamp them. But I would prefer to see that than go back to the IC law.
So what changes in specific you have in mind that would be helpful in maintaining the independence of the office?
So the fundamental concern that we have is some of the confusion that developed about the various roles here. What is the role of the Attorney General vis-a-vis the role of the special counsel? I will pick out the one proposal that we made that I think is novel, controversial, complex, however you want to look at it, but I'm going to pick on that first. And that is to build particular independence around the special counsel's fact-finding role. The special counsel plays, as independent counsels played before any special counsel was appointed, the special counsel plays a critical public role in resolving questions which we'll call what happened questions. Assume the president is the person under investigation, could be a senior cabinet official, but one way or the other, the special counsel is accounting to the public for the outcome of a factual investigation. And that factual investigation, we believe, needs to be protected. By the same token, the ultimate responsibility for determining whether a prosecution goes forward still rests with the Attorney General of the United States, and I suppose you could say ultimately really rests with the president. That's complicated.
You would not give the special counsel the authority to actually issue an indictment without permission from the Attorney General.
Special counsel can recommend.
Yes.
But the Attorney General has to take final responsibility. So people say, well, how in the world can that be? Particularly those who sort of don't remember fondly the days of Bill Barr. They're going to say, well, how does that possibly work? But structural reform requires recognizing that there are certain roles in our democracy that are discharged by identified officials for a reason. And we can quarrel, and I do quarrel, with the way Bill Barr handled his relationship to the Mueller office, at least as I was able to perceive it on the public record. So one could be critical, but at the end of the day, it seems to me that the Attorney General should retain responsibility for that final decision. Now, by the way, I should also mention we have other proposals having to do with the independence of the Attorney General and trying to shore it up in the area of law enforcement. So quite outside of the special counsel regulations, we need
We'll come talk about those as we get
right. But that is the fundamental. And then beyond that, I just want to mention, I won't go into this is one of the reforms that we decided we would commit to a notional set of proposed regulations. We have an appendix in which, in a few cases, we decide to lay out in actual formal regulatory or statutory language what we propose. And this is an example because it's complicated. But the other element of it that I would stress is, and it relates, by the way, to fact-finding, transparency. Transparency of the outcome of the fact-finding investigation by the special counsel, transparency about decisions that the Attorney General makes to interfere in the factual, in some way in the investigation of the special counsel, or to reject, for example, an investigative route that the special counsel may have decided upon, to block a legal theory that the special counsel may wish to pursue. And that is one where we believe full transparency is required, meaning really fundamentally, not just the public, but disclosure to Congress. So I hope that's an overview that's helpful here.
So as a law professor, always trying to figure out where to draw lines, would you consider the determination as to whether there was obstruction of justice a fact question or a law question in your?
Well, it's clearly both, because first you have to identify what the party of the investigation did, and then determine how the law applies to those particular facts. And I should mention, by the way, because this is an important piece, that we do think the obstruction of justice statutes need to be revised in very particular respects to apply clearly to particular actions by the president. So one thing I just want to stress again is that when you look at what we're doing with the special counsel regulations, or what we propose, the other reforms of the criminal justice process and the role of the president have to be sort of considered in conjunction with how we view the actual functioning of the special counsel rules.
Jeannie, Ree, tell me, what is your reaction to this? Do you think that would have made a difference? Should be done, Bob's suggestions, or do you have other thoughts on making the special counsel stronger, but not too strong, perhaps?
Thanks, Alan. And also thank you to Bob and to Jack for writing this book, because having lived day to day through the experience, one greatly appreciates after the fact a deep breath and a framework in which to actually think through in a more systemic, thoughtful, rigorous way the lived experience. So let me just level set by saying I agree with a lot of what Bob has said. You know, obviously, the special counsel regulations are born of a lived experience, and I think the large consensus view is that nobody has a particular desire to go back to the independent counsel statute. And frankly, if there was an independent counsel, I think the investigation with respect to election interference in the 2016 cycle would still be ongoing, and God knows where else it might have gone if past serves as prologue. With respect to the special counsel provisions, Bob is absolutely right that I think there was a lack of appreciation in the public perception about exactly what the rules of the road were and what the scope of the engagement was. And I think the real disconnect about public expectation and the regime under which the investigation was actually operating was a very wide gulf. And if nothing else, the book and these kinds of talks shedding light on that disparity of perception, expectation, and the reality of the scoped assignment is something that in the aftermath of that is important to, I think, digest. And looking forward, which is really what this panel is about, looking forward, making clear whatever the new rules of engagement are, whether they be the existing regulations or something statutory going forward, that there be very crisp articulation to the public about exactly what is within the purview of the investigation and what is not.
Do you think the public thought that Mr. Mueller had much more power than he probably did have under the existing regulations? Is that your perception of the problem?
I think that is a reality of one of the many problems about the kind of muddled nature in which the public perception of what was going on, the regulatory reality, and then all the complicated interstices, because this is really my last point, which is notwithstanding all the very good reform measures that are being propounded, it requires good faith actors, and every rule, once it's articulated, can be worked around by people who want to approach it without the best of intentions. To wit, even with respect to transparency, there are conversations that can be had where there are no directives. There are soft or stronger statements about caution and or views that if things should come to a head, it would result in the following. And so again, this is always the problem, I think, with rules and regulations, whether they be statutory rules or just regulations, that again, depending on who is coming to the table with respect to actually operating under said rules, you may have asymmetry, you may have different approaches. And so looking forward, this is just an imperfect area of practice when you think about the significance of what it is that oftentimes is called for an investigation that calls for a special counsel.
So let me ask both of you, under the existing regime, the regulations can be withdrawn at any moment for no reason at all, and the special counsel can be removed without any statutory or other protection. Does that trouble you in a respect, or do you think that's part of the compromise that we have to have? And so tell me, what are your thoughts about that? Bob, let me begin with you.
We think the special counsel should have removal protections. And as a matter of fact, it was interesting in the course of this entire extraordinary experience with the Mueller investigation, Trump did not fire Mueller, though, by the way, at various points, he did his damnedest to try to get that into motion. But members of Congress, even members of Congress who staunchly defended him in other respects, argued against dismissal. Now, I don't know whether we can look back on that and say it is the continued historical experience or recollection of what happened during Watergate. The words Saturday Night Massacre come to mind. And you can imagine political advisors to President Trump saying, "You'll never survive something like that. It'll look like a cover-up. It's extremely dangerous. Don't do it." I don't know whether that's the advice he got, but he didn't do it. And members of Congress on his own sides, again, very strong followers and sharp critics of Bob Mueller, counseled him against it. And there were statutes proposed to institute a restriction on removal. We think that's a good idea. That is one of the ways in which we think the special counsel ought to be protected in performing some of the core functions that we think ought to be retained for that role, including the one that I've emphasized, which is fact-finding, accounting to the public for what happened after an investigation performed by professionals under the special counsel's supervision.
But short of a statute, there's no way to protect the special counsel, is there?
No.
And it's not even clear after the most recent case, which I believe Jeannie's law firm represented Selah Law in the Supreme Court, in the case in which the court decided that statutory protection for the head of the Consumer Financial Protection Bureau was unconstitutional. Of course, the prior statute was upheld in Morrison against Olson, not me, but another Morrison. And so maybe that would be enough, but it would surely be challenged in court once again, and its law has been changed a lot since then. Okay, well, let's move off the special counsel and hoping we don't have to worry about that anytime in the near future. Let me turn to the Office of Legal Counsel, and let me start off with the other end of Pennsylvania Avenue, Bob, and tell me, what do you and Jack envision the relation between the White House counsel's office, where you served, and the Office of Legal Counsel, where Jack served, in terms of advising the president and, to a lesser extent, other federal agencies, which is more the job of OLC?
Absolutely. Well, I've come, first of all, I'll start by saying that what I have to say, I say with a sort of kind of bittersweetness, the job of White House counsel, which I held, was the best job I ever had. And I can't imagine looking back on my career and having missed out on it. Having said that, I do think it is it's a controversial office. It has been subject sometimes to overheated objections, but some structural objections. Bruce Ackerman at Yale, by the way, has written famously both in op-eds and a book. He thinks White House counsels are by and large lackeys who do the complete bidding of the president. He thinks the same thing, by the way, about the Office of Legal Counsel.
Okay, so that doesn't solve the problem then.
It doesn't solve the problem, but I come to the conclusion that I think that the White House counsel should not continue to metastasize as a small, metastasize is the wrong word probably, expand dramatically as a small to medium-sized law firm within the West Wing and next door at the executive office building. You know, at its peak, the White House counsel, particularly if there's a period of active oversight and investigation, the White House counsel's office can be over 40. Normally, if you add detailees to regular hires, you know, it's, you know, high 20s, early 30s. And it is an office, it seems to me, that on the one hand performs the indispensable function of providing the president with legal advice at close quarters in the fast-moving environment of the West Wing, but on the other hand will always be subject to the objection that the White House counsel and the lawyers in the White House counsels are essentially senior staff of the president. They will be wearing the team jersey, and the suspicion will always be that they're going to bend their legal advice as much as possible, and sometimes beyond limits, to what the president and the senior staff wants. So in our book, we propose that a White House counsel be retained. You can't deny the president the right to appoint a counsel or to have some on-location support available, but that it be a limited number and that the core legal analytic function be performed in the Department of Justice. To my mind, there's a difference in the environments, and having lawyers at OLC, some of whom might be dedicated to this task of supporting the president so that there's prompt turnaround, as you would expect for the issues that the president wants advice on, that operating in that environment, and I think the OLC culture has by and large over the years been a strong professional culture, is a better place, addresses public appearances more effectively than having those lawyers, you know, on the second floor above the Oval Office or immediately across the way in the executive office building. So our view would be move that core function largely over to the Department of Justice with only a handful of deputies and the White House counsel on location. I think that would help. Just one last point on the White House counsel's relationship to OLC. There's always going to be tension between the White House counsel and OLC. There's going to be tension between the White House counsel and the Solicitor General. The president, after all, is entitled to his or her constitutional views, to setting legal policy. And so there's going to be a desire on the part of the White House counsel to help the president facilitate the objectives for which he or she was elected. And that's going to bump up against sometimes the preferences of career lawyers in how to frame a particular issue, much less how to resolve a particular legal issue.
Let me ask both of you, does the fact that the head of OLC is a Senate-confirmed position give some support to the notion that they're more likely to be independent than the White House counsel? Jean, do you have a thought on that?
I think it's only marginal because, of course, they are nominated by the president and subject to the selection of the president. And there's always been a close relationship between the White House counsel's office and OLC. I think all the points that Bob just made are quite well taken. I think just coming at it from the DOJ perspective, though, I think one of the questions about the proposal that gets raised is much more express connectivity between the White House counsel's office and the staff of OLC, who are essentially dedicated, or at least some portion of that office is dedicated to doing the work of the White House counsel's office. I think it's a question of which way do the norms cut? Is it that the physical and psychic space between the White House and DOJ flow in the direction of DOJ, or does it actually flow in the direction of the White House? So I just raise that as a just question for what that kind of proposal would achieve in actual effect.
I don't know whether either of you have read this book by White House counsel in the Nixon administration, John Dean, called Blind Ambition. it's a wonderful book for people who are going into the government. And Dean makes the point that he was chosen to be White House counsel precisely because he would do exactly what Haldeman and Ehrlichman and Nixon wanted him to do. And so it's a great example of that very problem. Bob,
yes, but you could have the same argument with respect to the selection of an attorney general and anybody else at the department.
yes, I suppose that's right. Except there, as Bob said, there's not that kind of proximity. They're not. The president doesn't walk into their office or call them to come into their office on a regular basis, and that the geography does affect it in some respect. Bob, are there kind of issues at which you think that the White House counsel should focus their attention on, as opposed to the other kind of things? For example, leaving aside judicial appointments for a second, but other kinds of issues in which the president has maybe a special interest that maybe the Justice Department wouldn't see as from the same perspective, or wouldn't you divide it that way? I think you're on. You muted yourself.
I apologize.
Oh, you're still mute, Bob. You're still mute.
There we go. Sorry about that. There's no question that there are going to be different perspectives between, say, and I saw that regularly, between, say, career lawyers in different agencies, for example, and the White House lawyers. And because the White House lawyers are sort of immersed in the whole question of the president's program and how to achieve and facilitate the president's program. The Office of Legal Counsel, has a statement of principles and policies. It was developed and posted in 2010. I think it stayed up the entire time that Trump was president, interestingly enough. And one of the points that the statement of principles and policies makes is that the lawyers in the Office of Legal Counsel should give their best understanding of the law, but also ought to take very seriously their function in doing what they can in good faith to facilitate the president's achievement of his or her objectives for which the public elected the president, so in theory at least. And so that there's a push and pull there. The current president's program versus others who think there's a real difference between that program and sort of enduring institutional branch interests. So to answer the other piece of your question, what struck me when I was White House counsel was what a large part of the portfolio of the White House counsel has to do with advice on national security affairs. And I ended up relying very heavily on people who were vastly more expert than I was. I had a deputy White House counsel for national security affairs. I had a special counsel for national security affairs. And the deputy White House counsel was also the legal advisor to the national security advisor. And there you have, because of the urgency, the delicacy, public expectation, all of the issues that have arisen, for example, over presidential's exercise of authority since the quote unquote war on terror occupied so much of our public policy agenda. There you have an intense presidential interest in shaping a program for which he or she's publicly accountable and on which regular legal advice is required. That is, and that's one thing about the White House counsel's office that some people don't recognize. You can go from the sublime to the ridiculous, right? Lawyers worried about the authorization for the use of military force and its interpretation of a particular case, and other lawyers who were working through the requirements of legally holding the White House Easter egg roll event.
Asha, I want to bring you into the conversation. I should have done this before. Tell me about what you think about legal advice dealing with international affairs and making of war and so forth, and coming from the White House as opposed to the Justice Department or the State Department or someplace else. Tell me what you're thinking about that.
Well, I actually kind of wanted to go back to the special counsel because I had some thoughts about that. And one thing that I noticed often got overlooked on that discussion, and I think is not adequately addressed in the way that the regulations are written. The special counsel regulations really contemplate a criminal investigation, and what the investigation into the Trump campaign's links with Russia involved was also a counterintelligence investigation. And I don't know that it was entirely clear how that fit in. And maybe it did on the back end, but it seemed that after the fact, that part was maybe excluded or somehow placed, was ancillary to the main criminal investigation. And I got this sense from, some people had been on the special counsel team, and what came out that, the FBI thought the special counsel had it, the special counsel thought the FBI had it, and it's, we're not really sure where it went. And the conclusions of that have never, and they may not ever come out. These are classified investigations that involve sensitive sources and methods. But I think it's just this big loophole. And it highlights, I think, we can just put to the side for a second, just the general, DEFCON 5 when the president himself is a national security threat as opposed to just a criminal. But I do think that the special counsel regulations don't really address this particular problem that was raised. And I'd be curious to hear Jeannie's thoughts about that.
Can I ask you a question to follow up on
Yeah.
that? That is, if assuming that there is some difference between these two kinds of investigations, one results in an indictment or a non-indictment, what would the result of a national security investigation in circumstances like this produce? Would it produce recommendations or suggest that somebody lose their security clearance or changing something else in the law or operations? Tell me about your thoughts about that.
That's a really good question. If you were to find, for example, that there were people acting at the direction and control of a foreign government who were in, the innermost echelons of the Oval Office, I would think that you would need to have a classified report that would at least be presented to the intelligence committees in a closed hearing. If you have any basis for impeachment, that seems to be one. If your president is a foreign asset, but and they can't do that without that information. So there has to be some kind of at least mechanism for information flow about those conclusions. In terms of the practical outcomes, I don't know. Could you strip the people of the security clearances if they're White House personnel? When the president is an original classification authority, it's not clear to me. The other problem that I think the special counsel investigation highlighted was after the fact, where basically it was systematically undone. The prosecution's being taken apart. The pardons you can't do anything about, but there does seem to be something very odd about a regulation which appoints a prosecutor to be insulated from political influence. And then after that's all concluded, the person who was politically appointed can then, undo it by casting doubt on the conclusions, by, making presentations to the court saying that these were not appropriate. And it seems like there needs to be a check in there somehow. I don't know what that would look like, but it kind of defeats the purpose of a special counsel investigation if everybody can just be, their charges dismissed.
Jeannie, are you comfortable saying anything about what Asha has just said about the dual nature of the investigation?
I think I'm going to refrain with respect to the classified pieces of it, other than to just note the obvious that Asha has already spoken about, which is transparency in that context and in that arena. With respect to the undoing, I would just make this one observation. For as much as there's criticism about what came of the investigation and the indictments that were brought under that investigation, I would just put an asterisk to say that the process, for as fragile as it may have appeared, and Bob very rightly noted, as it was reflected in the report, that there were these moments in time when the entire operation was imperiled by the threat of termination. Nevertheless, there were indictments, a slate of indictments, robust in their presentation. They actually made it through the process for all of its fragility. They were they were charged, they were prosecuted, and whatever happened in the aftermath of the closure of that office and the investigation all played out in the public domain.
And there were significant people who were indicted, not just minor figures. So in that sense, it was robust. Bob, did you have any thoughts about?
Yes, I do a couple of thoughts. First of all, one thing about, I suspect the reading of the Mueller experience is going to change over time, which is part of the intense confusion and concern in some quarters. Obviously, it was a relief to people who thought the president was innocent and had been victimized, that, quote, no collusion, unquote, or no prosecution for obstruction of justice. But for those who were concerned about it, and I'm going to go to Hash's line of thought about this, that something didn't seem quite right. I do think that there are constraints within which these kinds of independent investigations operate, whether it was, and that's why you have to put independent a little bit in quotes here, just as a structural matter. But there's a 400-page detailed report that sat on the shelves of bookstores or was available through Amazon or however it was acquired, that provided an enormously rich account of the issues that were of concern to the public, could be read by the Congress. Congress could respond to it. The public could respond to it. And that's, again, why I think the fact-finding function is so important. In that respect, I think the Mueller report left behind the report as something very enduring, even if those who believe those prosecutions were inappropriately aborted, even if that's a frustration with the outcome of the investigation, as Jeannie points out, wasn't really anything Robert Mueller could do about that.
Or anybody else for that matter. Given the pardon power, which you talk about also.
Right. And then the second thing I want to say real quickly, just to bring again the interrelated parts of the conversation back, I do think you can do things to constrain the pardon power. Jack and I have an entire chapter on the pardon power. There are limits, to be sure. The president has broad constitutional authority, but there are restrictions, including, for example, use of the pardon to bribe. We do think that the federal law could be amended to very specifically target certain illegal uses of the pardon power. And we also think Congress could take the stand that self-pardons are prohibited. It was widely thought Trump would do that. He didn't, but there's no reason not to go ahead and be very clear. Presidents can't do it. Yes, it will be litigated, but we think there's a good chance that that prohibition would stand. And likewise, I do think there are amendments to the obstruction of justice law that could bring the president in explicitly and subject the president to liability for obstructive acts of a very specifically defined nature. And I raise that because we put that in the book as well as a way of trying to surround, if you will, the issue and not be too dependent, say, just on the special counsel to carry the day.
Okay, I'd like to shift over to what was going to be the original first part of our discussion here, which is the independence of the Justice Department. And I think everybody, certainly on this call and event, believes the Justice Department should be independent. And I guess the question really may mean, what do we mean by that? That is, in what sense should they be independent of the president? So let me give you a specific example. Suppose now the Justice Department begins an investigation and the possible indictment of former President Trump. And the question is, should the president have any say about those matters at all? Or should he just simply say, I'm staying absolutely clear of it. If you do this, Merrick Garland, that's your responsibility, but I, the president, don't have any. Or he should say, listen, I'm going to be the one who's going to take the fall if you indict the former president, especially if he gets acquitted. And I'm the president of the United States, and the Constitution gives me the right to take care that the laws will be faithfully executed. Where should the president come down on that? Bob, let me start with you, and then I'll go to the others.
First of all, the president absolutely, and again, if we take out obstruction, okay, and this in your hypothetical, we don't have to worry about that because it's a Democratic president passing judgment on the prosecution of a Republican predecessor.
I asked the question that way, yes.
Yeah, right, exactly. The president certainly could call up the Attorney General and say, I don't want to be faced with a pardon decision. This is going to tear the country apart. Unless you come here and tell me that this is an open and shut case of egregious criminal conduct, whatever it may be, I don't want you consuming up these resources. I don't want this to be a subject of division in the country. We have other issues to tackle. Can a president do that? Absolutely. No question.
Should he do that?
Pardon me?
Can, of course, yeah.
And prudentially, I mean, this is just my view. By the way, President Biden has spoken to this issue, but my view would be that is a mistake. That I think that at the end of the day, the public needs to know, and this is a very complicated issue, as all of the panelists here know, and you know, Alan, the president is above the law in some respects and not above the law in other respects, but he can't be above the law in all respects. And it seems to me that if a large issue is raised about presidential misconduct and it would be investigated in the ordinary course, it shouldn't be stopped simply because the president is the president. And so I do think the president should, the incumbent president should be ready when the prosecution proceeds to address the question of whether or not he or she will intercede, or at the end of a conviction, he or she will provide a pardon or a commutation of sentence. But I think it's important for the public to see that the justice wheels turn for the president as well as for everybody else.
And would you, we might take three different sets of events. One are the charges that the president has federal income tax criminal liability, pre-presidential, not before the president and before he was in office. Second, at the other end is any criminal responsibility for the events of January 6th. And then last, anything that happened between January 6th and January 20th of 2017. Would you view those all as the same if you were the president?
No, because I think, first of all, ones that are the existing prosecutions, the ones that are underway in New York and that may be underway in Georgia, apparently are underway in Georgia, it seems to me ought to be allowed to proceed unimpeded. That's a separate set of issues. I think the question becomes much more when presidents of the United States oversee the prosecutions of opposition party predecessors. However deserving those prosecutions may be, it is going to raise the specter that that will become a norm, and in bad hands are going to be used to the serious detriment of our democracy. Well, Trump will come in. I mean, there's Donald Trump saying, even though he didn't lose to Hillary Clinton, I want to prosecute Hillary Clinton. She should be in jail, right? We don't want that to be something ultimately that we hear on a routine basis. So again, I'm speaking only for myself here, and I'm not speaking for Jack, but let me just close by saying this. I would not think the president would want the government to go looking for crimes committed by his or her predecessor during the term of office. But if there was evidence of crimes committed during the term of office, then they should be investigated. And if those crimes indicate the investigation indicates the prosecution is appropriate, then the prosecution should be pursued.
Jeannie, Asha, thoughts on this subject?
I come at this picking out a line that particularly struck me out of Bob and Jack's book, and that is a line, and maybe it's a very thin line, but there is a line between permissible policy prerogatives and imperatives, political ones, and just partisanship. And here, you know, the hypothetical that you've posed, Alan, one, it's not quite a hypothetical, but it's where, at least in this circumstance, you know what is possible at the time that you're making a selection to be Attorney General. And it's, I think, perfectly permissible within our democratic construct for president to ask about these things in the selection of who is going to lead the department, because for as much as we talk about independence, it is only oh so independent. And of course, policy and political imperatives and priorities as articulated by Bob should be taken into account. And, you know, certainly when I was a career prosecutor, you know, I had no idea about the larger dynamics at play, right? Because I only saw things through the narrow lens of the cases that I was investigating and you know, the cases that I was pursuing. And that is not how you want to scope out, right? The aperture necessarily needs to be broader and wider, and it is appropriate for that to happen. I think the much harder case is what happens after there's already been an attorney general selected, something comes up, as Bob is talking about, where you just in the ordinary course of operation come upon credible allegations of criminality, and in the exercise, because there's always exercise of prosecutorial discretion, what do you do then? And that's a harder case, but I do think that, we all run the danger over course correcting based on recent lived experience, because what comes around always goes around. And, and I would caution against this notion that you have a department that is so far outside of the prerogatives, and again, appropriately so, of the administration writ large.
Asha?
Yeah, I think I'm with Bob on this. I mean, while I appreciate Jeannie's point, and there may be the realities that happen, between the White House and the Justice Department, and I think especially in this moment, there has been enormous damage to the credibility of the Justice Department as an institution that operates independently. And I think that perception is one that is going to take a long time to correct. And so, there can't be, I think, in this case, even I think the perception is really, it matters as much as the reality, in terms of there being any sense that President Biden has weighed in on the decisions of the Justice Department in what to do with regard to Trump. I personally think that, just in terms of the decision itself, that the anything pre-presidential seems like ought to be fair game, and anything post-presidential that they discover now ought to be fair game. So, I mean, do you treat a former president who's been discovered to engage in criminal acts, like, is that the same as, the acts that were committed while he was president? But yeah, I mean, I guess the short answer is I think that Biden should stay away from it with a 20-foot pole at this point.
So there are other kind of decisions which, if you took the argument of Justice Department independence too far, you would raise questions. So, for example, should the president be able to say, look, I want you to start doing something in the antitrust field about these tech companies. And I want you to commit resources to it. And I'm not telling you what the answer should be. Or in the civil rights area, I want to start with the policy of my administration to start investigating police. Or not investigating police, doesn't matter what the answer is. Is that an appropriate function for the president to say?
Yes, because those are policy decisions. Those are policy priorities. The question that you asked, though, was about what Biden, what influence he should have with regard to Trump. And in that case, he is a self-interested party. He has a direct benefit, and this is, goes in many ways to many of the issues that Trump raised as he was president, that he acted in ways and exercised his influence in ways to benefit himself politically. And I think that would be how I think it would be operating in fact, and also perceived in the case of the Biden-Trump thing. I think that, prioritize civil rights. Okay. It doesn't every Justice Department kind of follow the policy priorities of the president?
Maybe, depends on how far you take independence. Bob?
Well, so a hypothetical I like to use, and I particularly like using it in the Trump year with my students at NYU, because I knew it would be somewhat provocative, is to, at the time, hypothesize the case of a very progressive president. And I usually use in the hypothetical, this was before the election and before the primaries were really underway, I use the case of Bernie Sanders. So President Sanders wakes up one morning, reads in the Washington Post that the New York Times has an expose about the head of a very large financial institution who has done such and such. And Sanders is outraged. It's consistent with everything he believes about the behavior of the CEOs of large financial institutions. He calls the Attorney General of the United States and says, I read this in the New York Times. This is exactly what I'm talking about. If we lie down and do nothing, the public's going to believe that these people can operate with complete impunity. Go run this down. And if this SOB committed a crime, you prosecute him. I don't want to hear about, oh, the prosecutors think it's an extension of the normal doctrine. There are facts there to support a reasonable prosecution. Go get them. Now, that brings people up short, because there you have what seems like a targeted prosecution, but it overlaps very specifically with the programmatic and policy concerns of a particular president. Can the president do that? There's no self-interest involved. I mean, it's not like the president's taking money from anybody to do it. It's not to protect himself from legal liability. But, you know, the answer is, can the president do that? Yes. What would the White House counsel say? Probably, you know, ROA. I really wish in the future you would call me before you call the Attorney General in a matter like this. There's a way to convey the concern that isn't a direct order from the president to the Attorney General.
Jeannie, your thoughts?
I totally agree here. This is where norms matter, and there is a whole set of norms that had developed around interactions, conversations between the White House and the Justice Department. They're prudential rules of engagement that have served lots of administrations well, but let's just be honest and call them for what they are. They are prudential restraints that have served institutions well. And I do think that this is where, you know, we talk so much about the divide between D's and R's and the progressive or the more extreme wings of both of those parties. But I think there's a similar vector, a spectrum, right, of institutionalists and anti-institutionalists that cross-cut against the traditional just political divides, and they operate in pretty complicated ways. And I think this little hypothetical is maybe an encapsulation of that when you think about the ways in which that can all operate. You know, clearly I'm speaking as a deep institutionalist, and that is separate and apart from my own personal views about some of these questions, as Asha is rightly articulating, just in terms of public sentiment. But there are these distinctions to be drawn, and they're not, they don't perfectly map onto one another. In fact, they often don't map onto one another.
Bob, is that hypothetical copyrighted so I can use it in my class?
Well, go for it.
All right. So we have a couple of questions here. One is about Don McGahn slow walking the demand that Mueller be fired. The question is, what do we make of his actions as a lawyer in accordance with the rules of disciplinary conduct? Was he failing to carry out his boss's orders?
No, I wouldn't. McGahn is a complex figure. What we know on the public record. By the way, I think is one of the most consequential White House counsels ever to serve in that job. And as a matter of fact, wherever he goes, he's quite consequential. When he was chair of the Federal Election Commission, he was a consequential figure in Republican demolition of that agency, and did it very effectively, or at least contributed to it very effectively. I don't believe, based on what I know, that a slow walking that order on his part is a breach of his disciplinary responsibilities. I don't know precisely what it was that the president finally expected. Bear in mind, at some point, if I'm not mistaken, the president wanted him to deny that he'd ever been ordered to fire anybody. So there's a little inconsistency.
It would be hard to sustain a complaint if the lead witness said he didn't do it. Yeah,
exactly. I didn't tell him to do that. I don't know where he got that idea. But I think that speaking of somebody very close, Don McGahn had a history very similar to mine. He was a very political person. I knew Senator Obama longer than Don McGahn, I think, knew Donald Trump. But both of us were in the political world, and both of us probably didn't suit the Bruce Ackermans of the world as a choice for White House counsel. He ended up, nonetheless, staying in that job, performing quite to the satisfaction of congressional Republicans. He was very, very popular with congressional Republicans who were impressed with what he did with judicial nominations. And he also stayed in that job. This, to me, is one of the more interesting issues in the McGahn tenure. He stayed in that job while, and this is, I'm just talking about the Mueller report itself, Jeannie, not asking you to comment, testifying many, many times before the special counsel's office. Now, if I were the White House counsel and I'd go in the Oval Office and I'm like fresh from a meeting with the special counsel in a conversation about the president that bears on the president's legal liability, it's a very awkward position to be in. And it'll be very interesting one day whether Don speaks on the topic, writes on the topic, memoir, whatever it will be, how he was able to manage that. Because to me, the relationship would seem to preclude being a witness with that kind of threat posed to the president, just of being a witness against the president, potentially, whatever he intended the import of his testimony to be, and having that close confidential relationship with the president that a White House counsel has to be in order to be effective.
Bob, is that an argument suggesting that maybe the White House counsel is not necessarily the servant of the president in as much as we have suggested he might be in other circumstances?
He is, first order of business is for people to understand the White House counsel is a government employee and owes responsibility to the presidency and to the people of the United States. And that's where critics of the office say, well, that's well and good, but look at all the political associates presidents have put in that role. And it's meant to be an enabling role, and it's meant to blur the distinction between serving the president personally and serving the president as president, which is why I thought maybe that office ought to be downsized.
I want to give Jeannie and Asha a chance to say any further thoughts they have on these rather broad subjects they haven't had a chance to get in now, because we have only a minute or two left in the hour. Asha, let me begin with you.
On the same question.
Anything we've talked about, free play.
I'll let Jeannie go.
Okay.
I would just end on the, without comment on the ethical issues here. I do think that the question of serving the office of the president and the sanctity of the office of the president and the power of the office of the president and being a close advisor there versus serving the individual is, there's a lot of talk about it, but I again just want to pause on that, because I think this goes back to my just observation about that spectrum of being an institutionalist versus an anti-institutionalist, because you can be a very progressive D while still having very strong feelings about the office of the presidency and the need to serve that function in close working relationships with trusted advisors who can give candid and free advice in service of all of the priorities, the political priorities that come with that office. And therein lies the rub. So no answers, just some further observations about just the complications of this as we move forward into the future.
So let me interject a thought that just occurred to me, and that is the recent cases before the Supreme Court involving Trump's tax returns and the other cases involving the DC Circuit and Congress's efforts to get the testimony of Mr. McGahn, and the cases involving at least the president's tax returns on behalf of the Ways and Means Committee, as well as the other efforts to get presidential records, seem, at least for the time being, to be going in the direction of giving Congress the authority to get into court and with a sufficient showing, and they're not going to just say, well, Congress asked for it and we'll give it to them, a sufficient showing that they actually can get this. Might that affect in some way the dynamic we've talked about here in terms of the White House and the independence of the Justice Department and so forth, and the role of the White House counsel? Because we have another safety valve that may not have been fully available. At least it was been challenged by every president before, seeking when the Congress seeking information, either in the way of witnesses or in the way of documents from either the White House or the Justice Department. Bob, I see you're shaking your head.
No, I agree with you. I haven't really thought through. I mean, I think it would condition the environment in which the White House counsel gave the advice. By the way, I wanted to draw a footnote here and say I think McGahn had an obligation to cooperate with prosecutors, number one. So I didn't mean to suggest anything to the contrary. I just think it put him in an awkward position. And I also said he was most consequential. I guess I shouldn't treat John Dean that badly. He was certainly very consequential. So let's just say he's on the list of the most consequential White House counsels. But I agree with you. I think that the case law is part and parcel of the material with which the White House counsel has to define sort of the advice given to the president on these sensitive issues. And I think so I haven't thought it through, but it's an excellent question.
Anything further? Well, I see that the time is just about up, and I want to thank all of you for participating, and I want to thank Jack for standing in the background and being ready to participate. And maybe we'll have to find another time to get him up there and ask him a few of these questions and see if he has the same answers that Bob
I
has.
hope so. Otherwise, I'm going to be in trouble with Jack.
No. We'll give you an affirmative defense. We asked you, you were under subpoena, had to answer the questions under oath.
Okay, very good.
Had no-
Thank
had-
you so much. I really appreciate it. Enjoyed it.
Bob and Deborah and Russ, on behalf of the ACS, thank you all for putting on this program, and thank you for giving us the opportunity. And I hope that we can continue these discussions as we go forward. Thanks again, and
It's a pleasure.
Thank you.
thank you.